Hi everyone and welcome to part 2 of our webinar series. Today we're going to be focusing on leave and the National Employment Standards. We'll be covering a few things today. We'll have a look at what the National Employment Standards are, the 10 minimum conditions that apply to all employees. We'll go through who it does apply to. We will cover what leave entitlements apply to your employees. And the question we commonly get asked is, can I contract out of the NES? So we'll talk about that and ensure you're across your requirements as an employer. So who am I? My name is Nicole. I'm the Managing Consultant with Liquid HR. My background is in both HR and industrial relations. So I'm really looking forward to taking you through the National Employment Standards today and answering any questions that you do have. So what are the National Employment Standards? They are 10 minimum conditions of employment that apply to all employees. They're really there as a safety net to protect employees and make sure that they're getting their minimum requirements. If we have a look at what the 10 conditions are, they are maximum weekly hours of work, requests for flexible work arrangements, parental leave and related entitlements, annual leave, personal carers leave and compassionate leave, community service leave, long service leave, public holidays, notice of termination and redundancy pay, and lastly, the requirement to provide a Fair Work Information Statement to all new employees who join your business. So what we'll do now is we'll break that down into each of the areas, and I'll discuss some of the common things that you need to be aware of in relation to each of the standards. So if we look at the first point with the National Employment Standards, it's around maximum weekly hours of work. So the legislation states that the maximum weekly hours of work for a full-time employee is 38 hours per week. So the National Employment Standards were introduced on 1 January 2010. Prior to this, there were many organisations who were operating on a 40-hour work week. So at that time, a lot of businesses made the change from the 40 hours to the 38 hours. We still do see with some clients that the 40-hour does still exist. So it's really important that you do have a look at that within your business. One key thing I want to note here is it does state 38 hours per week plus reasonable additional hours. So I'm sure the next question you're probably all thinking, and that I get asked all the time, is what is reasonable additional hours? And this is often, it's not actually defined by the legislation. The Act doesn't define the word reasonable, but it does give you a list of things that you need to consider when determining if the extra hours the employee works are reasonable. It looks at things like in any regard to the employee's health and safety from working the additional hours. It also looks at other factors like the employee's personal circumstances, the requirement and nature of the business. There's a long list to go through. So if you are having employees in your business who are working more than 38 hours per week, it will be important to have a look at that and to be able to see if you need to make a change to that. Please reach out to us. We can help you work through that and work through the hours within your business to determine what's right. The second one from the National Employment Standards is the right to request flexible work arrangements. So there is a group of employees under the National Employment Standards who have a legal right to request flexible work arrangements. So this might be a change to their working hours, a change to start or finishing times. The group of employees that can request this are those who have the responsibility to care for a child under school age, anybody who is a carer. There's also employees who have a disability. If you have employees who are over the age of 55, or an employee who is experiencing violence from a member of their family or is supporting an immediate family member who is experiencing violence as well. The process for this is normally the employees put the request in writing asking what they're wanting their changes to be. They need to have at least 12 months service with you before they do that. This also includes casual employees if they've been employed on a regular and systematic basis. So when the employee does put the request in writing to you, you have 21 days to respond in writing. As a business, you can only refuse on reasonable business grounds. So you have to have a look. And the example I often give with that is, let's say, for example, you run a call center that is open from 9 to 5, and you have an employee who who works in the call center and requests to work 10 to 6. Now, look, provided you don't have any other employees that could provide additional flexibility or other work that employee could perform, you could argue that on reasonable business grounds you can't offer that flexibility. So there's a number of factors that need to be looked at. Also, it's important to be aware there was a change on 1 December 2018 where additional obligations were placed in modern awards that require employers to do a number of additional things in relation to requests for flexible work arrangements. You now need to make sure that you're going to sit down and discuss the request with the employee. So you can't just get a written application and respond in writing to them, you have to have a discussion. If you can't accommodate the request, so the example I gave earlier, you have to respond in writing to the employee after having the discussion, and you have to write the reasonable business ground for the refusal. You then also need to state whether there is anything else in your business that you can offer to accommodate the request. So if there's any other flexibility that you could provide. If you can offer other changes, you need to set out what those changes would be to the employee. So it's an important part of the National Employment Standards to be aware of. It could be a good idea to have a request for flexible work arrangements form within your business and just a simple process outlining what will happen once a request is received to ensure that you're meeting that 21-day obligation and following the process as per the National Employment Standards. Third part is parental leave and related entitlements. So this applies once an employee who's been employed with you for a period of 12 months, they can apply for unpaid parental leave. The period that they can apply for is initially 12 months. They can, once they're on their period of parental leave, so the 12-month period, 4 weeks prior to their return date, they can actually request an additional 12 months, so taking off 2 years in total as unpaid parental leave. The parental leave does apply to full-time and part-time employees as well as casual employees who have been employed on a regular and systematic basis. So in terms of process, the legislation states what the requirements are for employees, so it's good to have a policy in place or something which clearly explains to employees what they need to do if they're wanting to take a period of parental leave. So they're required to notify you in writing at least 10 weeks before going on the period of parental leave. And normally they put in there that they have the intention of taking parental leave, their expected start date of the period of parental leave, and the finish date. And then they normally confirm that 4 weeks before they go on leave so that you're able to make accommodations and changes within your business as to if you're going to recruit somebody on a fixed term contract to cover their role whilst they're on leave. The employees have the right to return to their previous position after a period of parental leave. Some employers do also offer paid parental leave. That's not a requirement under the legislation for you to offer that, but it is an additional benefit that you may wish to consider. The government does offer paid parental leave for 18 weeks at the federal minimum wage. Employees normally apply for that themselves through the Department of Human Services, and then either the Department of Human Services will pay the employee directly. Sometimes they will send you as the employer a lump sum and you're required to make those payments, but you'll get notification of that if that is the case. So look, parental leave is something to be aware of. The only other thing I will flag there is that the National Employment Standards does allow for what they call paid keeping in touch days when an employee is on a period of paid parental leave. So the whole idea from that is it's a few days where the employee can come back into the business. It might be for meetings or to make sure that they're still across things so that it assists them in their transition when they're returning. Next one, the one most people are familiar with is annual leave. So full-time employees get 20 days annual leave per year. It accrues from the first pay period for the employee, so it will accrue progressively throughout the year. And if they're a part-time employee, they'll still get annual leave, but it will accrue based on their hours of work. Casual employees, as many of you are aware, are not entitled to annual leave. Annual leave is paid out on termination of employment. One question that we do often get is, can employees cash out their annual leave? It can be cashed out, but only under certain circumstances. So if the employee is covered by an award, you need to check if there's a provision in that award that allows the cashing out of annual leave. If it's an award-free employee, annual leave can be cashed out if there's an agreement in writing and if the employee has a remaining balance of at least 4 weeks. So, in terms of taking annual leave, it's normally agreed between both parties. If you do have an annual closure, you can direct employees to take a period of annual leave over that period. So there's just some requirements. It's good just to negotiate it with each of your employees when the requests come through, and have a process in place around how you're going to manage annual leave requests and ensuring that all your employees aren't off at the same time. Next provision is in regard to personal carers and compassionate leave. So for personal carers leave, this is often referred to as sick leave, but it covers two different types of leave. So for full-time employees, they're entitled to 10 days per year. Part-time employees, pro rata amount based on their hours of work. Casual employees don't get personal carers leave. So personal carers leave is to cover for two things. One, if the employee is ill or injured and unable to attend work, or secondly, if they need to care for an ill or injured immediate family member. So they can apply for it. You can, as an employer, request evidence. So if the employee has taken any absence, you can request a medical certificate or a statutory declaration for that. If an employee does exhaust their personal carers leave entitlement, so let's say, for example, they've been employed with you for 6 months, but they've already taken their 10 days, they would go into a period of unpaid leave whilst on personal carers leave. In regards to the accrual of personal carers leave, much like annual leave, it accrues from the first full pay period. It is carried over from year to year. However, it is not paid out on termination of employment. The second leave that we've referred to there is compassionate leave. So this leave for full-time and part-time employees is paid, and it's 2 days per occasion in the event the employee has an immediate family member that is terminally ill, or if they have passed away, so to attend the funeral. So 2 days per occasion, so it really depends. Some employers do request evidence for that. It's completely up to you as a business. I would probably say use what is fair and right and apply it consistently throughout your business. It can often be a really difficult time for employees, so you probably want to think about how you approach that situation. Community service leave is another provision of the National Employment Standards. There's probably two elements of community service leave. The first one is if you have an employee who does engage in what they refer to as an eligible community service activity, which is, say, for example, they're a member of SES or a voluntary emergency management body, they can actually take a period of unpaid leave when performing that work. The second part of community service leave is in regards to jury service. This is treated a little bit differently. If an employee has to attend jury duty, as an employer, your obligation is to make up a difference between what the employee has received from the court and their normal wage for a period of 10 days. After that 10 days, the court will continue to make payments to the employee, and they will go on a period of unpaid leave. Long service leave. Long service leave is an interesting one. By way of background, in January 2010, the government really streamlined employee relations and implemented the Fair Work Act. What happened then was everything became national, and there were the same conditions that applied regardless of what state you operate in. However, unfortunately, one area the government hasn't been able to make the same across all states is long service leave. So we still have separate state legislation, and the entitlement to long service leave varies depending upon what state the employee works in. So if we look at New South Wales, it's covered by the Long Service Leave Act 1955. Employees need to be employed for a period of 10 years before they become entitled to approximately 8.6 weeks long service leave. There is a pro rata entitlement in New South Wales between 5 and 10 years. That can apply in two different circumstances. One, if the employee resigns on account of illness, incapacity, or what they refer to as a domestic or pressing necessity. So people always ask, well, what is that and what does that mean? The example I give for that is If the employee's partner has to move interstate for work, or they're moving, they're resigning on account of domestic or pressing necessity, and would be entitled to pro rata long service leave. If you're unsure, reach out to us. We can look at the situation and be able to determine if it falls into that category. The other entitlement to pro rata long service leave, if the employee is terminated for any reason other than serious misconduct, you're required to pay pro rata long service leave between 5 and 10 years. The other states also have different requirements, so if you do have any questions, like I said, reach out and we'll be able to help you through that. Public holidays. So this part of the National Employment Standards really talks about the fact that employees are entitled to be absent from work on a public holiday. You can request an employee to work on a public holiday if the request is reasonable. The legislation often refers to reasonable on numerous occasions. Yet again, it doesn't define reasonable, but it does give you a list of things that you need to consider in determining what is reasonable and what isn't. So they ask you to take into consideration factors such as the workplace in which the employee works, the nature of the work performed. So for example, businesses that are 7-day, 24-hour operations, it would be probably deemed reasonable that you request some employees to work on a public holiday because you're going to need staffing for that, particularly common in hospitality and retail industries. You need to consider the employee's personal circumstances, whether the employee will be entitled to receive overtime, payments, penalty rates. There's a big list of things to consider in determining what is reasonable. Next National Employment Standard is in regards to notice of termination and redundancy pay. So two separate things under this standard. The first is notice of termination. So if you do terminate an employee in your business for any reason other than serious misconduct, then you need to provide a period of notice, which is outlined in this provision of the National Employment Standards. The period of notice is based on how long that employee has worked in your business. So if they've been working for you for less than 12 months, it's 1 week notice required. For more than 12 months but less than 3 years, 2 weeks notice. For more than 3 years but less than 5 years, 3 weeks notice. And for more than 5 years, 4 weeks. If you have an employee in your business who is over the age of 45 and has at least 2 years continuous service with you, you actually have a legal requirement to provide an additional week's notice on top of that. Keep in mind that obligation doesn't require the employee over the age of 45 to give you an additional week's notice. It only goes one way under the legislation. If you do terminate someone, the notice of termination needs to be given in writing. We do have a webinar coming up which covers unfair dismissal, which is something to be aware of in regards to termination so that you can make sure you're following the correct processes and managing any risk to your business. The second part of this standard is in regards to redundancy pay. So when we look at redundancy, it occurs when the job the employee is performing is no longer required to be performed by anyone in the business. So, for example, you might have a restructure, there might be a downturn in your business, you might have decided to outsource a particular area of the business. So when that occurs, the employee's role is said to be redundant. There's really specific obligations you must follow when you make an employee redundant. And the first of these is that you must consult with the employee regarding the change. You need to listen to their feedback on any alternatives that could be considered other than the redundancy. You also need to look at if the employee can be redeployed anywhere else in your business in any other capacity, or if you do happen to have associated entities, you also need to have a look at whether they can work within the associated entity as well. If that isn't possible, and the business decides to proceed with the redundancy, this provision of the NES sets out the redundancy pay the employee is entitled to. So if an employee is made redundant, they would be entitled to redundancy pay based on their length of service. So it ranges anywhere from 4 weeks up until 16 weeks. They also receive notice of termination, payment of any unused annual leave, as well as any potential pro rata long service leave or long service leave that they've become entitled to. It's important to note that there's specific tax rules for how redundancy pay is taxed, but essentially a component of the payment up to a particular threshold, which is set by the Australian Taxation Office, is tax-free. So you need to make sure that you're meeting those requirements as well. If you are looking at making someone redundant, please get in touch with us first so we can discuss the process with you. If an employee does believe that their redundancy wasn't genuine, and for example, if they believe you've made their position redundant, but then you've recruited somebody else in that role a few weeks later, they can actually make an application to the Fair Work Commission for unfair dismissal. So, as I mentioned earlier, we do discuss the unfair dismissal process in detail in the upcoming webinar. So please tune in for that. We'll be able to talk you through what you need to know in that space. Finally, the last requirement is to provide a Fair Work information statement to employees. This is a 2-page document. It outlines the employee entitlements and who they can get in contact with for further information. You do need to provide it to anybody who commences with your business, so it's a good idea to put it in a new starter pack with the other documentation provided to the employee upon commencement. Really important question here, can I contract out of the NES? Quite simply, no, you can't. As we state there, the National Employment Standards are minimum conditions for every single employee. You can't come to an individual agreement with an employee to reduce any of them below the NES. So that brings us to the end. Thank you for coming along and learning a little bit more about the National Employment Standards with me. If you do have any questions, please get in touch. We'd love to hear from you. Our contact details are below. You can give us a call or email us. I look forward to speaking with you soon in another upcoming webinar. Thanks very much. Bye.